Today, we're diving into the top 25 real estate exam practice questions on topics that you will most likely see on your exam. These questions are designed to sharpen your knowledge and boost your confidence for the big day. So, how will this work? Well, I will provide you the question, give you some time to answer it, then provide you with the answer and an explanation. Feel free to pause the video if you need more time to answer the question. So get ready, grab your pen and paper, and let's tackle these questions together. Let's get started. Number 1. Which type of mortgage typically includes a partial release clause? Is it A, construction mortgage, B, package mortgage, C, blanket mortgage, or D, wraparound mortgage? The correct answer is C, blanket mortgage. Remember, a blanket mortgage is a type of loan that covers multiple properties. The partial release clause in a blanket mortgage allows the borrower to release certain properties from the mortgage once specific conditions are met. So remember, when you see partial release clause, just think blanket mortgage. Now, let's talk about why the other options aren't the correct choices. So in a construction mortgage, this type of mortgage is used to finance the construction of a new property. And a package mortgage is a loan that covers both real estate and personal property, like appliances or furniture, as part of the same agreement. And a wraparound mortgage is basically when the borrower makes payments on an original mortgage amount and then receives a secondary mortgage from the seller. Number 2, what is a necessary condition for a deed to be considered valid? Is it A, the grantee must sign the deed? B, the consideration must be in dollars? C, it must contain a subordination clause? Or D, it must contain a granting clause? The correct answer is D. It must contain a granting clause. Now, let's talk about this one and why that is the right choice. Remember, a granting clause is a very important component of a deed because it states the intent to transfer ownership of the property from the grantor, which is the seller, to the grantee, the buyer. Now, without this clause, the deed would not effectively convey ownership rights, making it invalid. Now, let's talk about the other ones. So, in letter A, the grantee must sign the deed. So, while this is important, the absence of the grantee's signature does not inherently invalidate the deed. The essential element is the granting clause that conveys the deed. Now, why is B not the answer? Because the consideration, although it refers to something of value exchanged between parties, which is usually money in a contract or an agreement, this consideration is a fundamental aspect of a contract. It doesn't have to be specifically in dollars for a deed to be valid. Consideration could be various forms, in like money, goods, or even services. And letter C, it must contain a subordination clause. Well, a subordination clause, remember, is found in mortgage agreements typically, and it deals with the priority of liens on the property. Number 3, which of the following is not considered a public land use control? Is it A, zoning, B, environmental protection laws, C, subdivision regulations, or D, deed restrictions? The correct answer is D, deed restrictions. Public land use controls are regulations imposed by governmental bodies to manage land use and development within a community. These controls aim to promote public welfare, safety, and orderly development. Now, let's talk about why deed restrictions don't fall under this category. Public land use controls such as zoning, environmental protection laws, and subdivision regulations are enforced by governmental entities at various different levels, like local, state, or federal. Zoning regulations dictate how land within certain areas can be used, such as residential, commercial, or industrial purposes. Environmental protection laws govern activities that may impact natural resources, ecosystems, or public health. Subdivision regulations establish standards for dividing land into smaller lots, ensuring infrastructure and amenities meet community needs. On the other hand, deed restrictions, also known as restrictive covenants, okay, are private agreements imposed by property owners or developers. Number 4. You have received verbal consent to park in a friend's driveway while attending a football game. This permission is considered an easement appurtenant, B, an encroachment, C, a license, or D, literal right. The correct answer is C, license. All right, so in this scenario, when your friend verbally gives you permission to park in their driveway, it's essentially granting you temporary permission or authorization to use their property for a specific purpose. This type of permission is referred to as a license. Licenses, remember, are revocable agreements that allow someone to use another person's property for a particular purpose. Now, let's talk about the other ones. Remember, an easement appurtenant is a right that's granted to a property owner to use a neighboring property for a specific purpose, such as access or utilities. It's a more formal and permanent arrangement than a license and typically involves 2 adjoining parcels of land, not just temporary permission. All right, so what's an encroachment? Remember, an encroachment occurs when a structure or improvement on one property extends beyond its legal boundaries and onto another property. And D, literal right. Literal rights pertain to property owners' rights and privileges regarding the use of water bodies like lakes, seas, or oceans. All right, moving on to number 5. It says the obligation for a lender to utilize the settlement statement form for certain government-related loans stems from A, ECOA or Equal Credit Opportunity Act, B, RESPA or Real Estate Settlement Procedures Act, C, Truth in Lending, or D, Federal Housing Administration FHA regulations. The answer is B, RESPA. Remember, RESPA stands for the Real Estate Settlement Procedures Act. It's a federal law that governs the procedures and disclosures involved in real estate transactions, particularly those involving residential properties. One of the key provisions of RESPA is the requirement for lenders to use the closing disclosure form for certain types of loans. Now, let's talk about the other ones. So, ECOA or Equal Credit Opportunity Act is also a federal law, but that prohibits lenders from discriminating against credit applicants based on factors such as race, color, religion, national origin, sex, marital status, age, or receipt of public assistance. And TILA or Truth in Lending, that requires lenders to disclose the terms and costs of credit transactions, including the APR or annual percentage rate and other finance charges. And D, the Federal Housing Administration or FHA regulations. Well, FHA regulations pertain to loans insured by the Federal Housing Administration, which provides mortgage insurance on loans made by FHA approved lenders. Number 6. Among the given options, which one would not typically be classified as a lien? Is it A, encroachment, B, judgment, C, mechanics lien, or D, mortgage? The answer is A, encroachment. So remember, a lien is a legal right or interest that a creditor has in another person's property as security for a debt or obligation. It basically allows the creditor to take legal action to seize the property if the debtor fails to fulfill their obligation, such as repaying the debt. Now, let's talk about the other ones. Remember, a judgment lien is a court imposed lien that's placed on a debtor's property as a result of a court judgment against them. Now, a mechanics lien is a type of lien that contractors, subcontractors, or suppliers can place on a property if they haven't been paid for work or materials that were provided for that property. And a mortgage is also a type of lien on real property that's used to secure a loan. When someone takes out a mortgage to purchase a home, the lender places a lien on the property, allowing them to foreclose and take possession of the property if the borrower defaults on the loan. So these three options, judgment, mechanics lien, and mortgage, are all examples of liens because they represent a creditor's interest in the debtor's property to secure payment or fulfill an obligation. However, encroachment refers to the unauthorized intrusion or trespass of a structure or improvement onto another person's property. While encroachment involves a boundary issue and can lead to legal disputes, it doesn't typically involve a creditor's interest in the property as a security for a debt or obligation. So it really would not be classified as a lien. Number 7. What term describes a contract where the intentions of the parties are demonstrated through their actions rather than explicitly stated? Is it A, an express contract, B, an implied contract, C, a bilateral contract, or D, an executory contract? The answer is B, an implied contract. All right, so remember, an implied contract is a legally binding agreement where the terms and obligations are inferred from the conduct, actions, or circumstances of the parties involved, rather than being explicitly stated in writing or verbally. In other words, the agreement is implied based on the behavior or actions of the parties, even if they haven't explicitly discussed or agreed to specific terms. For example, if you go to a restaurant and order a meal, there's an implied contract that you'll pay for the food you receive. This agreement isn't explicitly stated, but it's understood based on the customary practice of paying for goods or services received. Now, let's talk about why the other ones aren't the correct choices. So, an express contract, remember, is a formal agreement in which the parties explicitly state the terms and conditions of the contract, either orally or in writing. The terms are clearly articulated and agreed upon by both parties. A bilateral contract is a type of contract in which both parties make promises to each other. Each party agrees to do something in exchange for the other party's promise to do something else. It's basically characterized by mutual promises. And an executory contract is basically a contract in which one or more parties have not yet fulfilled their obligations. In other words, there's still outstanding duties or performances that need to be completed by one or both parties. Number 8. Which of the following groups of people is not protected against housing discrimination by fair housing laws? Is it A, women, B, college students, C, ethnic minorities, or D, families with minor children? The answer is B, college students. All right, let's talk about the federal fair housing laws. Remember, these laws prohibit discrimination in housing based on certain protected characteristics. These laws aim to ensure equal housing opportunities for all individuals and prevent discrimination based on the factors like race, color, religion, national origin, sex, familial status, and disability. Now, let's discuss why college students are not specifically protected under federal fair housing laws. So, women is sex discrimination and is prohibited under the fair housing laws. Now, ethnic minorities, that's discrimination based on race or national origin. And D, families with minor children. Remember, familial status discrimination is also prohibited under federal fair housing laws. And this includes discrimination against families with minor children, such as refusing to rent or sell housing to families with children, or imposing different terms or conditions onto them. Now, when it comes to college students, those are not specifically identified as a protected class under the federal fair housing laws. Discrimination against college students in housing may occur for various reasons unrelated to the protected characteristics outlined in fair housing laws. Number 9. Which type of listing agreement offers the greatest protection to the broker? Is it A, exclusive agency, B, exclusive right to sell, C, net listing, or D, open listing? The correct answer is B, exclusive right to sell. This arrangement offers the highest level of protection to the broker because they're assured compensation for their services, regardless of the circumstances surrounding the sale. Now, let's talk about the other listing options. In an exclusive agency listing agreement, the seller grants exclusive rights to one broker to represent them in the sale of the property, but the seller retains the right to sell the property themselves without owing a commission to the broker. So a net listing, let's talk about that one. That's a type of listing agreement where the broker's commission is based on the sale price of the property exceeding a specific amount, with the excess amount or the net going to the broker. Net listings are generally discouraged and illegal pretty much in most states due to potential conflicts of interest and lack of transparency. And then open listing, well, an open listing agreement allows the seller to bring on multiple brokers to market the property, with only the broker who successfully procures a buyer will receive commission. Number 10. Which of the following loan types falls under the category of conventional loans? Is it A, a privately insured loan, B, an FHA loan, C, a Freddie Mac loan, or D, a VA loan? The correct answer is A, a privately insured loan. All right, so remember, conventional loans are mortgage loans that are not insured or guaranteed by the government. Instead, they're offered by private lenders like banks, credit unions, or mortgage companies. And they adhere to guidelines set by Fannie Mae and Freddie Mac, which are government-sponsored enterprises, or GSEs, that purchase and securitize mortgages. Now, an FHA loan is another type of mortgage, but insured by the Federal Housing Administration, or FHA, which is a government agency within the U.S. Department of Housing and Urban Development, or HUD. FHA loans are not conventional loans because they are backed by the government and have different eligibility requirements and guidelines. Now, a Freddie Mac loan, okay, well, we all know Freddie Mac, or the Federal Home Loan Mortgage Corporation, is one of the two GSEs we just talked about, along with Fannie Mae. While Freddie Mac plays a role in the secondary mortgage market by purchasing and securitizing conventional mortgages, a loan directly from Freddie Mac would not be considered a conventional loan. Instead, it would be a loan that conforms to Freddie Mac's guidelines for purchase in the secondary market. And VA loans, they are mortgage loans guaranteed by the U.S. Department of Veteran Affairs, or the VA, and are available to eligible veterans, active duty service members, and certain surviving spouses. They are not conventional loans because they're backed by the government and have specific requirements and benefits tailored to military service members. Number 11. Which of the following statements would a seller's agent not typically be required to disclose as a material fact? Is it A, the roof was replaced 5 years ago? B, there was a termite infestation 3 years ago, but it was treated and resolved? C, buyer's ability to make a lower offer? Or D, the property is located in a flood zone? The answer is C, the buyer's ability to make a lower offer. As a seller's agent, there's a duty to disclose material facts about the property to potential buyers. Material facts are those that could affect a buyer's decision-making process or the value or desirability of the property. Now, the buyer's ability to make a lower offer is not typically considered a material fact that the seller's agent is required to disclose. Now, let's briefly talk about why the other options might be considered material facts. Now, A, the roof was replaced 5 years ago. Well, this information about the roof being replaced is definitely considered a material fact as it provides insight into the condition and maintenance history of a significant component of the property. B, there was termite infestation 3 years ago, but it was treated and resolved. Well, disclosing past termite infestations, I don't know why I can't say that, even if treated and resolved, is generally considered a material fact as that also pertains to the property's history of pest issues, which could affect the buyer's decision. And if the property is located in a flood zone, well, this is just another example of a material fact that a seller's agent would typically be required to disclose. Number 12. According to capital gains tax law, a single person may exclude up to $250,000 in capital gains from taxation on the sale of a home if they have lived in the house for at least A, the past year, B, 2 of the past 5 years, C, 1 of the past 3 years, or D, 2 of the last 4 years. The correct answer is B, 2 of the past 5 years. Under the capital gains tax law in the United States, individuals can exclude up to $250,000 in capital gains from taxation on the sale of a home if certain conditions are met. So, single people, $250,000, married filing jointly, $500,000, and both of those have to live in the property 2 of the past 5 years. Number 13. Jack gave Harry a deed without providing any explicit or implied guarantees. The deed is most likely A, general warranty deed, B, special warranty deed, C, bargain and sale deed, or D, quitclaim deed. The answer is D, quitclaim deed. A quitclaim deed is a type of deed commonly used to transfer ownership interest in a property without providing any warranties or guarantees about the title. When someone uses a quitclaim deed to transfer property, they're essentially transferring whatever interest they have in the property, if any, without making any promises about the quality of the title. Now, let's talk about all the other ones. What's a general warranty deed? Well, that's a deed that provides the highest level of protection for the buyer because it includes explicit covenants or promises from the seller regarding the quality of the title. This type of deed typically includes warranties such as covenant of season, the covenant of quiet enjoyment, and the covenant against encumbrances. Now, a special warranty deed, also known as a limited warranty deed, that includes warranties from the seller, but only for a specific period of time during which the seller owned the property. It provides less protection than a general warranty deed, but more than a quitclaim deed. And a bargain sale deed conveys the property from the seller to the buyer, but it doesn't include any warranties about the title. However, unlike a quitclaim deed, It implies that the seller has the right to convey the property, but doesn't explicitly state that the title is clear of defects. All right, number 14. Among the following liens, which typically would be granted the highest priority? Is it A, a judgment issued last year? B, a mortgage recorded 4 years ago? C, a special assessment? Or D, a mechanic's lien for work begun 2 months ago? The answer is C, a special assessment. When it comes to liens, priority refers to the order in which creditors have a claim on the property's assets in case of a default or foreclosure. Generally, the lien with the earliest priority gets satisfied first from the proceeds of the sale of the property. In this case, a special assessment typically holds the highest priority among the options that were provided. A special assessment is a tax or fee that's imposed by a government authority, usually a municipality, to fund specific public improvements or services that directly benefit the property, like road repairs or sidewalk installations, etc. Because these assessments are backed by the taxing authority and are usually mandatory, they often take precedence over the other liens, including mortgages and even judgments. All right, number 15. The basis for your city's zoning ordinance, which dictates the types of buildings that can be constructed in specific areas, is grounded in A, eminent domain, B, police power, C, escheat, or D, riparian rights. The correct answer is B, police power. All right, remember, zoning ordinances are regulations implemented by local governments to control land use and development within their jurisdictions. These ordinances dictate how land can be utilized and what type of buildings or structures can be constructed in specific areas, such as residential, commercial, industrial, or mixed use zones. Now, let's talk about why the other options aren't the correct choices. So, we all know eminent domain, that refers to the government's power to acquire private property for public use with just compensation to the property owner. And escheat is the legal process through which property reverts to the state when an individual dies without leaving a will or legal heirs. And riparian rights, well, that pertains to the legal rights or property owners adjacent to water bodies such as rivers, lakes, or streams. Number 16, a statement such as nicest neighborhood in town that exaggerates the qualities of a property is most likely characterized as A, fraud, B, puffing, C, misrepresentation, or D, material fact. The answer is B, puffing. Puffing refers to exaggerated or subjective statements or opinions made about a property that are not considered factual, but rather opinions or subjective judgments. Statements like nicest neighborhood in town are examples of puffing because they are subjective opinions about the property rather than verifiable facts. In real estate transactions, puffing is common and generally not considered fraudulent or actionable because it's understood that such statements are opinion and not meant to deceive or mislead buyers. Now, let's talk about the other one. So, fraud, that involves deliberate deception or misrepresentation with the intent to deceive and gain an unfair advantage. Now, misrepresentation, that involves providing false or misleading information about a material fact with the intent to induce someone to enter into a contract or transaction. Now, material facts, those are very important objective details about a property that could influence a buyer's decision to purchase. Number 17. When a listing agreement includes a broker protection clause, the clause typically A, allows the broker to terminate the agreement early without penalty, B, allows the broker to buy the listed property if the broker is unable to sell it. C, automatically extends the listing for 6 months if the broker is unable to see the property. Or D, extends the broker's commission rights beyond the expiration of the listing period. The correct answer is D. It extends the broker's commission rights beyond the expiration of the listing period. A broker's protection clause, which is also known as an extender clause or safety clause, is basically a provision in a listing agreement that protects the broker's right to receive a commission on the sale of a property even after the listing agreement expires. This clause typically states that if the property is sold to a buyer who was introduced to the property during the listing period, the broker is still entitled to receive a commission. That's why we get things in writing, ladies and gentlemen. All right, moving on to number 18. Which of the following would not be classified as real property? Is it A, trees, B, buildings, C, trade fixtures, or D, water rights? The correct answer is C, trade fixtures. All right, so real property, let's go back, also known as real estate, typically refers to land and anything permanently attached to the land. That includes improvements such as buildings and structures. It encompasses physical assets that are immovable and permanently affixed to the land. Like trees. Trees that are growing on land are considered part of the real property. They're affixed to the land and are not intended to be removed without damaging the land. Now, buildings and structures erected on land are integral parts of the real property. They are permanently attached to the land and are not intended to be removed without significant effort or damage. And water rights, well, water rights refer to legal rights to use water resources such as rivers, lakes, or groundwater. While water itself is not considered real property, the rights associated with its use and access can be classified as real property interests. So trade fixtures, remember, those are items of personal property that are affixed to real property by a tenant or business owner for the purpose of conducting business. Like a dentist would need a dentist chair, an x-ray machine. Those are trade fixtures. So unlike fixtures that are considered part of the real property, like a chandelier or a built-in bookshelf, trade fixtures are generally removable by the tenant or business owner at the end of the lease term without causing damage to the real property. Therefore, trade fixtures are classified as personal property rather than real property. All right, number 19. The giver of an option is called the A, executor, B, optionor, C, vendee, or D, optionee. The correct answer is B, optionor. In a real estate option agreement, the party granting or giving the option is referred to as the optionor. So remember, the ORs are the givers, the EEs are the receivers. So the optionor is the property owner who grants the option to another party, which allows them the right to buy the property at a specified price within a certain period of time. What's an executor? Well, an executor is a person appointed to administer the estate of someone who has passed away according to the terms of their will or based on the applicable laws of intestacy. Okay, now a vendee is the buyer or purchaser in a real estate transaction. Now, optionee, the optionee is the party who receives the option in an option agreement, and they have the right to buy the property from the optionor who gave the option within the specified time frame and the agreed upon price. So the giver of an option, don't forget, is an optionor. The giver is the OR. The receiver is the EEs. Moving on to number 20. An appraiser attempting to determine the value of an income property through capitalization of the income stream will consider which of the following factors? Is it A, mortgage interest, B, net income, C, replacement costs, or D, income taxes? The correct answer is B, net income. All right, so remember when appraising an income producing property such as rental property or commercial building, an appraiser will use the income capitalization approach to estimate its value. Remember, in this approach, the appraiser analyzes the property's income stream to determine its potential value to investors. Remember, cap rate is net operating income over market value. So definitely net income is the number one answer here. Now, why is it not mortgage interest? Well, mortgage interest is typically not factored into the income capitalization approach directly. Instead, it's considered an operating expense when calculating the property's net income. And replacement cost, well, replacement cost refers to the cost of rebuilding or replacing a property with a similar one at current market prices. And of course, income taxes, well, they're also typically not factored into the income capitalization approach directly. However, they indirectly affect the property's net income and cash flow, which can influence its value to investors. But investors may consider tax implications when assessing the property's potential return on investments, but taxes are not a direct consideration in the income capitalization approach. So when determining the value of an income property through the capitalization approach, the appraiser primarily considers factors such as the property's net income, operating expenses, and investor expectations regarding return on investment. All right, 21. Among the following licenses, who is most likely to act as a general agent for a client? Is it A, a broker, B, property manager, C, cooperative broker, or D, listing salesperson? The correct answer is B, property manager. A property manager is most likely to act as a general agent for a client. Here's why. A general agent has the authority to act on behalf of the principal or the client in a broad range of matters within a specific scope of authority. While other licensees like brokers, cooperative brokers, and listing salespersons may also represent clients in real estate transactions, their roles are often more limited in scope compared to property managers. They may act as agents in specific transactions or represent clients in certain capacities, but their authority may not extend to the same breadth of matters as property managers. So a real estate agent would be considered a special agent. So therefore, among the options, a property manager is most likely to act as a general agent for a client. All right. Number 22. How many brokers participate in an exclusive right to sell listing agreement? Is it A1, B2, C, as many as the owner or lister chooses, or D, as many salespeople as the broker has in his or her office? The correct answer for this one is A1. In an exclusive right to sell listing agreement, only one broker is involved, typically. So remember, in exclusive right to sell listing agreement, the property owner or seller grants exclusive rights to one specific broker or brokerage firm to represent them in the sale of the property. The broker is the only agent authorized to market and sell the property during the listed period. This means that no other brokers or agents can represent the seller during this time frame. If the property is sold within that listed period, regardless of who finds the buyer, whether it's the listing agent or another agent, the listing broker is entitled to the commission. All right. How are we doing out there? Here we go. We're getting closer to the end. Number 23. All of the following would terminate the agreement between the broker and the owner except A, death of the listing salesperson, B, death of the owner, C, death of the broker, or D, bankruptcy of the broker. The correct answer is A, death of the listing salesperson. In a typical real estate listing agreement, the death of a listing salesperson, while pretty sad, it does not mean it terminates the agreement between the broker and the owner. Sorry to say, agents, but yes, that is true. Remember, the brokerage firm basically can assign another salesperson to handle that listing and continue representing the owner in the sale of that property. Now, the death of the owner, on the other hand, will definitely terminate the listing agreement, and the death of the broker may or may not terminate the agreement. That depends on the arrangements made by the brokerage firm. So if the brokerage firm has mechanisms in place to continue operations in the event of the broker's death, the agreement may continue with another authorized individual within the brokerage. Bankruptcy of the broker may also terminate the agreement, as that could affect the broker's ability to fulfill their obligations under the agreement. So the death of the listing salesperson is the only option that does not typically terminate the agreement between the broker and the owner. 24. A contract signed by a drunken man is A, valid, B, void, C, voidable, or D, unenforceable. The answer is C, voidable. When a contract is voidable, it means that it is valid and enforceable unless one of the parties chooses to void or cancel it due to certain legal grounds. In this case, if a contract is signed by a drunken person, it's considered voidable. So void contracts, remember, a void contract is one that is not valid from the get and can't be enforced by either party. Void contracts lack legal effect, typically because they involve illegal activities or violate public policy. Now, voidable contracts is one that is valid and enforceable, like we just discussed, unless the party with the option to void the contract chooses to do so. Contracts signed by individuals who lack capacity, such as those who are intoxicated at the time of signing, fall into this category. While the category is initially binding, the intoxicated party has the option to void if they can demonstrate that their intoxication impaired their ability to understand the terms of the contract or enter into it knowingly and voluntarily. So a contract signed by a drunken man is considered voidable, meaning that it is valid and enforceable unless the intoxicated party chooses to void it due to their impaired state at the time of signing. All right, number 25. The relationship of trust and confidence that a broker has with a principal is called a fiduciary relationship, B, agent relationship, C, brokerage contract, or D, principal affiliation. The correct answer is A, fiduciary relationship. Okay, remember, a fiduciary relationship is a legal and ethical relationship of trust and confidence between two parties, where one party, the fiduciary, is obligated to act in the best interest of the other party, the principal. In real estate, brokers have a fiduciary relationship with their clients, such as buyers or sellers, where they are obligated to represent their clients' best interests and act with loyalty, honesty, and integrity. Thanks for tuning in to this comprehensive rundown of the top 25 real estate exam questions that you may see on your exam. I hope you found this video helpful in reinforcing your understanding of key concepts. Remember, practice makes perfect, so don't give up. If you enjoyed this video, be sure to hit that like button and subscribe to our channel. Just call Maggie for more valuable content on real estate exam preparation and industry insights. Feel free to leave any questions or comments down below, and don't forget to share this video with anyone you think might benefit from knowing this information. Until next time, happy studying and best of luck on your real estate exam journey.